A local NBC reporter is saying Steve Gonsalves has told NBC News. Steve Gonsalves has told NBC News. This has been the mystery we've all been wondering about. Why did the two roommates in the morning call the police about an unconscious person when there was apparently a bloodbath in their home? And this is what we are learning, that Steve Gonsalves may have told this NBC News outlet, that you've got to remember these two girls were so upset that when they went outside after seeing this, it wasn't very legible. They couldn't quite understand what the girls were seeing. He's referring to the 911 operator trying to make sense of what these two girls are saying over the phone, but he's saying that they ran outside having seen something horrible. And then he goes on to say one passed out and the other one was hyperventilating, that the message wasn't clear enough for the operator. This makes a lot more sense, that maybe those girls did see part of or some of the bloodbath in the morning and tried to call and could not get the message out to the operator. And one of them was hyperventilating and the other is passing out. And then they just say, hey, we got an unconscious person. We got an unconscious person there. I want to bring in Mark O'Mara. He's a criminal defense attorney and civil rights attorney as well. This, Mark, has been a missing piece for a long time. And I mean, it certainly helps us to understand the mystery of the morning. But there's still a lot of holes. And I just want to get your thoughts on that for starters. And then I'm going to ask you all about the defense.
Yeah, there's so much intrigue in this 6 or 8 hours that nobody called anybody. Perhaps there was something that we don't know about yet. Perhaps they were drinking, or not to impugn their integrity, but were they intoxicated on drugs or alcohol or something? That makes a lot more sense than this woman sees this attacker, or at least a stranger, in her house with a mask on, drives or walks by, and she does nothing for the better part of 6 or 8 hours. That makes no sense, and quite honestly, may well be fodder for the defense, because defense attorneys just look for anything to suggest an inexplicable event, and that's reasonable doubt.
So what about the notion that Kohberger matched one of these roommates, DM? We know it's Dylan because we've been talking about these surviving roommates for quite some time. Dylan said that he had bushy eyebrows. She saw bushy eyebrows. That's manna from heaven. That's manna from heaven for prosecutors to have a witness actually give that kind of detail about a face. Not just, you know, he was 6'2" or 5'10" and a light build. It's bushy eyebrows.
No question that that is going to be one of the sort of star pieces of evidence of a prosecution's case. The witness on scene can identify at least 3 or 4 or 5 different characteristics of this person. Again, this is an extraordinarily strong case of forensic tying together a noose, if you will, around Kohberger's neck already. And we've only seen 17 pages. Before we're done, Ashley, you know, there's going to be tens of thousands of pages of discovery on this case.
It's true. Okay, I got to ask you about cell phone pings, because we've been, you know, making huge hay about cell phone pings. Literally have a roadmap, you know, to Brian Kohberger. But there was one line in the affidavit that I thought, I know Mark O'Mara is going to seize on that, and every defense attorney out there will seize on it. It said that his cell phone pings in Moscow, November 14th. That's the day after. That's Monday after the murders. But investigators, quote, do not believe the phone was in Moscow on that date. Well, then why should anybody believe the phone was in Moscow on any of the other days? Is that what a defense attorney will say in this case?
Absolutely. It's that one little string that you want to pull on, that seed of doubt that may grow into reasonable doubt. In and of itself, maybe not enough, but we don't know what she's doing for 8 hours. Now we know the phone wasn't there. Now we know why wasn't she saying anything. Now we know that 100 people have left DNA. Why his? There's so much more information that needs to come out. But I will tell you, if the next couple of 3 or 4 months are as good an investigative technique as the last couple of months to get us to this point, they've done quite a good job. And of course, with FBI assistance, I must say, the best law enforcement agencies in the world, they're going to tie down every loose end on this one.
Do they ever? Because just that timeline that we're looking at on the screen right now, it's got a 2-hour hole in the cell phone, right? Police say that's just when he turned it off because he didn't want to be pinged there. But he's leaving Pullman and then he disappears and then he's coming back to Pullman before and after the murders. And is that doubt or is that reasonable doubt or is that nope? Nope.
Well,
it depends on what the jury thinks, if it's reasonable or not.
Causes of death, involve his family, and he knows what he did to our daughter.
And this crime scene still has not changed. There is now a police officer monitoring this home behind me 24/7. Police tell us they still do not have a suspect in custody or a weapon. Something that happened earlier today could make finding that weapon even harder. The dumpster right next to the home is now empty. Waste crews cleared it out earlier on Tuesday. Police quickly stopped the trash truck from going any further. We were on scene for the whole encounter. We asked police why this happened and are still getting no answers. Moscow police say they aren't commenting on the trash removal or anything else in this homicide investigation.
There's quite a bit of blood in the apartment and, it's a pretty traumatic scene to find 4 dead college students in a residence. There's quite a bit of blood in the apartment and, it's a pretty traumatic scene to find 4 dead college students in a residence.
The Latah County coroner is commenting, saying the scene she saw on Sunday was gruesome. And any new clues are needed in the investigation.
Could be some evidence of the suspect that we get during the autopsies, which would be helpful.
The bodies are now in Spokane County with autopsies happening on Wednesday.
So many different stories were starting to be created.
U of I students just want answers. These guys are on the golf team and say the lack of communication from police is doing everything but calming concerns.
I think the confusion, at least for me, and I think all of us, has only heightened in the last couple days, especially.
The small, tight-knit Moscow community is now shattered by these homicides before the holidays. And we also know the FBI from Salt Lake City is now coming in to help this investigation. Still, they aren't commenting, saying they are not the lead agency moving forward. We'll continue to keep asking questions and looking for answers as this community grieves and confusion continues.
Without talking about Maddie.
These girls were best friends since 6th grade, inseparable. They lived in a house together. They were true, ultimate best friends. And Maddie had been a huge part of our life.
Like Maddie, Kaylee was a high achiever, due to graduate from college early, and had a job lined up with an IT firm in Austin, Texas. So she just moved out of the house on King Road, bought a new car, a Range Rover, and had gone back to Moscow for one last weekend.
And she said, well, I want to go show Maddie my car, and there's a pie-pie party tonight, and I want to go to the pie-pie party. That was the last time that I saw Kaylee.
Amazing futures that were taken away by a monster. The man accused of this horrific crime has denied doing it and has proclaimed his innocence. There's no eyewitness, there's no confession, and there is no direct evidence. There's no eyewitness, there's no confession, and there is no direct evidence. It's a case that the prosecution has built on circumstantial evidence which they believe is compelling. We'll take a closer look as we continue to investigate the Idaho student murders.
Now to the latest out of Idaho. During a recent court appearance, the attorney representing Brian Kohberger said that prosecutors are withholding information from the defense team. His attorney argues that two upcoming hearings this month should be made public. And says prosecutors have not provided the full video that allegedly shows Kohberger's white Hyundai by that home where the four students were killed. And says prosecutors have not provided the full video that allegedly shows Kohberger's white Hyundai by that home where the four students were killed. Kohberger's attorney also arguing that the case should be continued to be made public. The prosecuting deputy attorney rebutting, though, saying that while the trial will be public, not all of the hearings should be due to the information being discussed. Now, Kohberger is accused of stabbing and killing Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin in their home just off of the university's campus back in November of 2022. Here now to discuss the very latest developments in this case, News Nation legal analyst and criminal trial attorney Sarah Azari. Sarah, thanks for joining us on this tonight.
Good to be with you, Natasha.
So, Sarah, the families of the victims are so frustrated right now. They're speaking out saying that this case is turning into what they are calling a hamster wheel of motions, hearings, and delayed decisions. What do you make of Kohberger's attorney's latest claims?
Yeah, I empathize with the families of these victims. It's difficult to be waiting for justice in such a horrific case and not really understanding that these are not delays for the sake of delay. The biggest, I think the heaviest claim, the recent claims that Ann Taylor's made, to me is the one that stands out is the idea that the prosecution is withholding evidence. That's really, really important. And you pointed out the video. We're past the idea that we don't have everything and not everything is ready. Now it's intentional. Ann Taylor has been very careful about saying in these motions that she's not accusing the prosecution of withholding evidence. And now she's saying they are withholding evidence because we're coming up on almost 2 years. And now she's saying they are withholding evidence because we're coming up on almost 2 years since the crime, and discovery should be complete. Discovery should be complete. Discovery should be complete. There's a price to pay. The defendant is deprived of his right to a fair trial. The defendant is deprived of his right to a fair trial. The judge might say that the evidence is kept out, doesn't get to come in at trial. And, we're seeing this in the Scott Peterson case. If some of this is Brady evidence, decades later, if Kohberger's convicted, it could pave the way to an exoneration. If some of this is Brady evidence, decades later, if Kohberger's convicted, it could pave the way to an exoneration. So it's a very serious accusation, and I think it's true. So it's a very serious accusation, and I think it's true. So it's a very serious accusation, and I think it's true.
Yeah, that is such an important point. And, let's talk about the alibi here. Kohberger's attorney's claiming he does have an alibi for the night that these four students were murdered. They claim that he was driving in several areas outside of that town that evening, that he was not near the home, Prosecutors now argue that his alibi comes up short of the legal standard. They are urging the judge to reject it. It seems like an easy way to confirm his whereabouts would be to use his cell phone data. But we see prosecutors saying that information does not rise to the level of an alibi. Cell phone data has been used in other cases as evidence, so why shouldn't it be used in this case?
I think there's got to be some reason forensically that his data maybe is not conclusive of where he was. But let's talk about cell tower data. The idea of connectivity of his phone to cell towers. Up until now, prosecutors have been saying the fact that his phone was not connecting to the cell towers that were, connected to the area around the crime scene, that means he's a, savvy murderer. But let's talk about cell tower data. The idea of connectivity of his phone to cell towers. Up until now, prosecutors have been saying the fact that his phone was not connecting to the cell towers that were, connected to the area around the crime scene, that means he's a, savvy murderer. He was the guy who slayed these 4 people and then turned off his phone. But now suddenly when he's trying to use same cell data, from towers in a different area to show that he was somewhere else, which is what an alibi is, somehow now it's inadequate. I mean, that's kind of convenient. But now suddenly when he's trying to use same cell data, from towers in a different area to show that he was somewhere else, which is what an alibi is. Somehow now it's inadequate. I mean, that's kind of convenient. But now suddenly when he's trying to use same cell data, from towers in a different area to show that he was somewhere else, which is what an alibi is, somehow now it's inadequate. I mean, that's kind of convenient. I think that inadequacy and reliability of cell data evidence is something that the jury will ultimately decide, and it's going to be a battle of experts. But an alibi is an alibi, that the person was not at the crime scene, they were somewhere else at that time, and that it's corroborated. And in the age of digital footprints and cell data, why not have it corroborated by cell data information and also experts who can testify about it? Why not have it corroborated by cell data information and also experts who can testify about it?
News Nation legal analyst Sarah Azari on this. Thank you so much for your time tonight.
Invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation. Again, exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through V deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor.
Tomorrow.
Right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge.
Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that. Puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Brian's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state trying to protect Brian's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Brian in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Brian have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on
in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents. But this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Brian has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Brian's innocent. Your Honor, Brian is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor.
The court is ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider, too, how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Brian has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. That any closure, it gives you this balancing test. We just went through the balancing test and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. To do with training records. That is not what we're contemplating discussing at this hearing on the 14th.
Your Honor, we would request that we start on defendant's motion to compel and second motion to compel. I believe the third motion to compel will be heard on a different date.
True.
As it relates to the two motions to compel, and I'll present my arguments whenever the court's ready, but I can direct the court exactly to the numbers in those motions to compel that are still up for discussion today and a request of ruling of the court.
Excellent. I'm ready.
On the original motion to compel, we are only seeking the court to order number 6 be complied with in that motion, in that particular motion.
Okay, let me take a look at that. Number 6. And so this is the motion to compel discovery that was filed on May 4th.
Yes, Your Honor, that's correct.
Number 6. And that is request number 160.
That is for request number 160, and that was in the second supplemental discovery request.
Okay, thank you. All right. And we're getting... Is that me? Okay. Number 6 from
Number
May 4th.
6 on that one, yes. On the
Okay.
second motion to compel, Your Honor, we are needing the court to order on request number 1, number 4, number 5, and I think that we have a plan for the other numbers, so those would be the 3 we need the court's order on.
Thank you. So let me make sure we're looking at the same page. Okay, number 1 is request 1. Number 4 is request 23.
I'm sorry, Your Honor, it's number 2, request 4.
Okay, I apologize. Number 2, request 4. Okay. And then you said number 5?
And number 5, which is request 109.
Okay, thank you. All right. And that's the second motion to compel discovery.
Correct.
All right. Do you want to make an argument about those?
I would love to.
Okay, go ahead.
Thank you. Your Honor, first, I want to start with talking about the discovery process. As the court knows, we have been representing Mr. Koberger since the very end of December of 2022. And during the course of the last several months, there has been a lot of discovery that's been requested and a lot that's been supplied. I come here asking the court to compel discovery. I'm seeking an order directing that we receive this discovery. I'm not seeking any other kind of sanction. I don't come here saying that the prosecutor has done something wrong. I come here saying that there are things that we have a disagreement about whether I should get them or when I should get them, and we seek a court order to assist us in this regard. Yesterday, we filed an exhibit that related to our motions to compel, and the purpose of that exhibit was to show the court how the discovery is coming in and what we are weeding through to try to find the information, and to let the court know that our office is making extraordinary efforts. Mr. Koberger's team works nonstop, and when we ask for discovery, it's because we have reason to believe it exists. So I wanted the court of counsel to be aware it's not a fishing expedition. These are real items that are really necessary to investigate this case and prepare Mr. Koberger's defense. So with that as the background and the frequent communication with the prosecutor's office to try to obtain the materials we need, we have come to an impasse in a few areas, and that's what brings us to court today. As the court knows, discovery is governed by statute 1309 and Idaho Criminal Rule 16. And the purpose of discovery is really to prevent an unfair trial, to prevent trial by surprise, and also to protect a charged person's rights to meet their defense. It protects their Sixth Amendment rights to have a sufficient and a prepared counsel, I should say, as we have a duty to investigate the case. So in preparing our case for Mr. Koberger, we've asked for several things that we still need. I'll talk first about request number 6 in the first motion to compel, and that stems from discovery request 160. It's training records. These are training records of 3 specific police officers. Your Honor, we have not asked for training records for every officer that has had anything to do with the case. I would not want to stand here and let the court think that this is an exhaustive list of the officers that we might need training records for, but these are 3 officers that we've requested them for, and the state has indicated they're not willing to give us the training records. These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations. We seek their training records to understand their processes. The training records, Your Honor, they are records that we've been able to obtain from various police agencies in the past. In this circumstance, are not records that I can find on my own. These are not things that are on the internet. They're not going to just hand them over to me. The 2 of the officers that we've requested them about are Idaho State Police officers. I have often received training records for Idaho State Police officers in the preparation of other cases during the course of my career. They are imperative for us to understand the specialty in interrogating and interviewing people, and for making the decisions that they made with regard to things taken as evidence in the case, or things followed up on or not followed up on. That is the purpose for those records, and we're asking the court to order the state to provide the training records for those 3 officers. Moving on then to our second motion to compel, and what we are looking for is a lot of information from the FBI CAST team, as well as the FBI Forensic Examiner team. What we're talking about here is the CAST team are the FBI examiners that used cell phone records to provide a lot of information that found its way into the probable cause affidavit that the state relied on in arresting Mr. Koberger. I had the opportunity to meet with the prosecutor, and they indicate that we will be getting those items in number 1 and number 6 disclosed to us, but we don't know when. So I'm asking this court to issue an order with a date certain to obtain those records. These are bits of investigation that the FBI conducted that relate to Mr. Koberger's cell phone, and the state has relied on that in their affidavit to say that Mr. Koberger was in certain places at certain times. So these are bits of information and analysis that's been done since December. We are now at the end of June. We do not have those records yet, Your Honor. They are something that's been relied upon by the state for the PC affidavit to arrest Mr. Kohberger, as well as to obtain a variety of search warrants. It's information that the state has agreed we should have. So we asked the court for an order with a deadline to get that. I want the court to know I don't think that Mr. Thompson or Ms. Jennings are trying to withhold this. I think they'll give it to me when they have it, but I think an order from the court saying this is the date certain may help them get the information a little bit more rapidly. I'll move on to our last request, and that's number 2 in the second motion to compel, request number 4. And that has to do with the FBI forensic examiner that told the state to look for a white Hyundai Elantra. This is the examiner that originally there were certain years looked for, and that year range was expanded. I believe I have the communications between the police department and the FBI about how that date range changed, but what I don't have is the report from the examiner. I did receive the CV, curriculum vitae, about the examiner late yesterday from the prosecutor's office, so I'm asking the court to order a deadline for the report to be given to the defense. Again, the court's read the probable cause affidavit that led to Mr. Kohberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Kohberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with a deadline so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense. As the court is aware that not producing discovery, especially when it's material, can be a due process violation. And as the court is aware, the state has filed its notice of intent to seek death against Mr. Kohberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Kohberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a heightened standard now that the state has filed its notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us. Thank you.
I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet. That, I'm sure, benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such. And the things that they have not given us, the drive test information, the verification of such.
That's the thing. I don't want to talk about those particularly. That's the thing. I don't want to talk about those particularly.
His phone was touching their Wi-Fi. Yeah, so you know how close that is. If you've had a laptop, you walk out into your front yard, you're not going to get too far. His phone was touching their Wi-Fi. Yeah, so you know how close that is. If you've had a laptop, you walk out into your front yard, you're not going to get too far. His phone was touching their Wi-Fi. Yeah, so you know how close that is. If you've had a laptop, you walk out into your front yard, you're not going to get too far.